All right. Good morning, everyone. This is the civil default calendar and hearings calendar for Judge Krause for Thursday, May 16th, 2024. The judge will be joining us momentarily. I'm on here to ask and to sound for anyone here on the case of American Express National Bank versus Anna Serna. Do we have anyone on that matter? Okay. All right. Thank you very much. And the judge will be with us momentarily.
Good morning.
Morning.
Good morning.
My system is operating a little slow. I don't know if it's the result of my internet or otherwise, so I apologize in advance. I'm going to run through the calendar really quickly and just get announcements, figure out the lay of the land, and then we'll circle back and take them in the best order. Hopefully some of you I can get on your way pretty quickly, but we'll see. So let me start with Brookwood Park Condominium Association versus Brian Wolfgram.
Alex Silva for Brookwood Park.
Mr. Silpa, have you had any contact with Mr. Wolfgram, or were you expecting his appearance today?
I was not expecting his appearance. He sent us a settlement offer that was far below what was acceptable, and that's the only contact that we've had recently.
Okay. Okay. So what I'm going to do then is I'll keep calling the calendar, wait just a few minutes, and then when I circle back, I'll just have you run through your default presentation, and then we'll go from there, okay?
Okay, thank you very much.
Thank you. Wellstar Atlanta Medical Center versus Metro Hematology and Douglas Collins.
Good morning, Your Honor.
Good morning.
Fenimore on behalf of the plaintiff.
Hi, Mr. Fenimore. How are you?
Good. Good morning, Judge.
Good morning. And I see Mr. Collins. Mr.
Douglas Collins.
Hi,
Douglas.
sir.
Yeah.
Do you have an attorney, Mr. Collins, or is it Dr.
No.
Collins?
No, I don't.
Okay. Okay. Thank you, gentlemen. American Express National Bank versus Anna Serna. Do I have any here on behalf of
Judge,
Anna?
I sounded for anyone on this case. No one appeared. This is Zwicker and Associates.
Okay.
And as I may have mentioned to you, they do have a motion for default judgment that is in the system, and it was there yesterday as well. It just hasn't been accepted yet for some reason. If they're not seeking attorney's fees, that might be why they have not appeared at this hearing.
Okay, well, if you could just reach out to Al and find out if they could please release that document so we can see it.
Certainly.
And then we'll wait until the end of the hearing and see what to do. But thank you.
All right, thank you.
Niskey Lake Falls Homeowners Association versus Flavius Harris.
Good morning, Your Honor. Floyd Dickens on behalf
Hi,
of
Mr.
Niskey.
Dickens. How are you?
Doing well, and yourself?
I'm doing well. Thank you for asking. Have you had any contact with Mr. Harris? I see Mr. Harris.
Hello, how you doing?
I'm doing fine, sir. Mr. Harris, do you have an attorney, sir?
No, ma'am.
Okay. Okay. If you guys will wait, I'm just calling my whole calendar, Mr. Harris, and then I'm going to circle back to your case in just a few minutes. Okay.
Okay, thank you.
Thank you, sir. And then, Mr. Freehoff, am I correct that the Labatt versus Mick Alta Management, they resolved with an order, correct? Just checking something. Okay. Ruben Lublin versus Angela Ruffin et al. Who do I have on that matter?
Yes, Your Honor. This is a counsel for petitioner Ruben Lublin.
Is it Miss? Please tell me how to pronounce your last name, ma'am.
It's Zhu, Z-H-U, Zhu.
Zhu. I just wanted to make sure I said it correctly. So thank you, Miss Zhu.
Appreciate it.
And who do I have here on behalf of Angela Ruffin et al.?
Your Honor, Burke Saul's
Good-
here
good-
for Community Association of Valley Lakes.
Okay.
Good morning, Your Honor. This is Cordero Kyla on behalf of Ms. Angela Ruffin, Rosalind Robinson, Kelly Ruffin, and Lawrence Ruffin.
Okay. And
And
do I have
David
anyone else
Stewart
here?
for Fidelity National.
Okay. And I think my understanding of this matter is that there is, I mean, it's an interpleader, but that there is some, do we have agreement as to the order and priority? Oftentimes these matters are resolved when, by the time they get to me, everybody's sort of agreed on the priority and then we can, you know, separate it out that way. Is that not where we are on this one yet, Ms. Ju?
Yes, Your Honor. I'm not aware of any agreement between the parties, and I
Okay.
believe seeing from the docket, there's some dispute between the lien priority holder between the Fidelity and Angela Ruffin.
Okay, understood. Okay, and how long do you think it might take to sort of work through these matters and make a presentation on behalf of your clients, Mr. Let's start with Mr. I apologize, Mr. Kyler.
Yes, Your Honor. I anticipate it being about 10 minutes.
Okay, and Mr. Sauls?
Your Honor, 2 to 3 minutes. Our position is we would be first priority.
Okay, and Mr. Stewart?
5 minutes, maybe, just a couple of minutes.
Okay. Okay, thank you all very much. I am going to go back to the beginning and start with Brookwood Park Condominium Association versus Brian Wolfgram. Mr. Silpa, if you want to just go ahead and make your presentation regarding the default matter.
Good morning, Your Honor. The defendant was served on March 18th. The service was filed in March 20th of 2024. He has not filed an answer. We have checked for, he is not a member of the active member of military service, and he is not bankrupt. Since he has not filed an answer, we move for a default in the amount, with the principal in the amount of $7,666.45. Interest in $15.94, attorney's fees $3,042, court costs $245.91 for a total of $10,970.30. Our association has a retainer fee, our relationship with Brookwood Park. As such, we charge a certain fixed rate for certain items. For the instance of this default hearing, we charge $500 to file the motion. Everything else falls in the realm of $225 per hour with various intervals of for different filings.
Okay. Okay, Mr. Silpa, I have seen your proposed order and yesterday. I thank you for sending it. And it does appear that everything is has been appropriately presented. I agree with you that Mr. Wolfgram is in default and that more than 15 days has passed since he became in default, and that your client would be entitled to a default judgment on that basis. And the numbers that have been presented seem to be documented and appropriate. So we'll go ahead and finalize that order that you submitted and get it on file for you. Okay?
Thank you very much, Your Honor.
Thank you, Mr. Silpa. Have a good day.
You too.
Okay. Next up is Wellstar Atlanta Medical Center versus Metro Hematology. Okay, so let me bring us all back to where we, I think, were when this hearing was set. So Wellstar Atlanta filed suit and served Dr. Collins and Metro Hematology on February the 28th. My best calculation is with the notice having been filed on March the 4th, so the time for filing would run from the original date of service. And so the answer that needed to be filed by the defendants was due, excuse me, on or before March the 29th. No answer was filed. We had a hearing previously, at which time I believe Dr. Collins, you did not appear. No one appeared, I believe, is my recollection, on behalf of either Metro Hematology or on your behalf. But we reset the hearing because in the interim, what we realized was that Dr. Collins had filed an answer and counterclaim on April the 12th, which was while the case was still in default, but during the time that Dr. Collins could have opened the default as a matter of right under Georgia law upon payment of costs and filing of an answer. And so I said, let's move this hearing to another date to find out if Dr. Collins is going to appear, and then to figure out what exactly is going on relative to the defendants and the status of the case. And so I think that's where we are. Since then, Dr. Collins, I'll note that I have received from you, I know you filed a motion to set aside default judgment. I'm going to be persnickety or particular about the naming of it, but just so you know, I haven't entered a default judgment. I have said that plaintiff is entitled to a default judgment as to Metro Hematology because they've never answered. But I've not actually entered that final judgment. So I'm going to interpret your motion as a motion to open default. But the complicating factor here, Dr. Collins, is that Metro Hematology is a professional corporation that it is required to be represented by a lawyer, and nothing has been filed on their behalf. I've seen things filed on your behalf, which you're authorized to do. So that's sort of where we are. Mr. Fenimore, I'm going to ask, because technically we're still here on your motion for default judgment, if you would like to add, correct, address anything that I've said, and then I'm going to call on Dr. Collins.
No, Your Honor, you recapped it perfectly. That's exactly how I had prepared it. And I guess I'm just wondering, the one thing that Your Honor was not completely certain about was payment of costs. It does not appear that that's happened. Mr. Collins said in his motion that there was a submission fee. That might just be the $19.55 that you pay when you file an answer. But my understanding is you actually have to physically go down to the court and pay costs and get them to reflect that. So if he hasn't paid costs, that would be a barrier for him to even open the default if he didn't do it on time. So I'm wondering if Your Honor had any information on that.
So as far as I can tell, as of today, there has been no payment of costs. I think the only real issue, and this is where I'm going to throw it over to Dr. Collins for a moment, and then I'd give you a chance to respond, Mr. Fenimore, is what Dr. Collins has brought to the court's attention is that he attempted to file a response on March the 28th, which would, I think, have been a timely response. I haven't looked at my calendar yet, but I think it would have been a timely response. But that filing was rejected by the clerk of court, and Dr. Collins did not determine that until April the 12th, when he then refiled that answer. Dr. Collins, can you let me know, address that issue for me in terms of what you filed and that sort of thing, sir?
Yes, Judge. I apologize first for not having a lawyer, and I don't have a lawyer because Wellstar has devastated my practice, and I'm up to my neck in debt as a result of them closing Atlanta Medical Center. I cannot afford a lawyer, can barely afford to keep the doors open. We filed initially in paragraph form, and when they sent the email the next day, we thought it was just proof that they had received the response. And then when I checked, it said that it could not be, the response had to be an answer to normal questions and not in paragraph form. That's when we resubmitted it. And so that's what the delay was about. It's not because we didn't think it was significant or something that we should have responded to. It's just the fact that mostly that I don't need an hour lawyer and I'm winging it.
Okay. Well, let me caution you, Dr. Collins. I certainly understand your limitations. I hear from people in your position sometimes frequently that occurs, but just as you would not want someone trying to practice medicine that wasn't fully qualified, you are not doing yourself any favors by trying to wing it legally. That's just my I can't give you legal advice. That's just my encouragement to you, sir, that you're almost always better off if you've got to appear in court with an attorney. And as I mentioned earlier, the professional corporation isn't allowed to be represented by an individual. It's only allowed to be represented by an attorney. So I want to make sure that you're aware of that, Mr. Collins,
Okay.
or Dr. Collins, I'm sorry.
Judge, can I make one other comment?
Yes, sir.
I was not aware of another hearing. One of the problems is that the Atlanta Medical Center is boarded up. The building that they're renting to me does not have mail access. The post office has declared it as permanently closed. You don't get any mail at all. The letters Mr. Fenimore submitted as part of his proof that he had notified us, none of those are signed because we never received any mail. We haven't received mail at that address in 1 year. And they've caused us undue trouble because Medicaid reimbursed it based on address. And when they found out that their address was no longer valid, we had to reapply to Medicaid and to Medicare because that address is no longer valid. The doors are locked. There's no receptionist. There's no security. So there's no mail that comes into the building at all. Okay. And so Mr. Fenimore's admonition that he has warned us and sent us letters he may have, but the post office doesn't deliver. We have proof, multiple letters we've sent to the post office requesting mail delivery, and it appears that that address is permanently closed.
Okay. Thank you, Dr. Collins. Mr. Fenimore, if you would like to respond, I would like for you to particularly address the issue associated with the attempt to file and then the refile in April, and whether you think that changes the outcome, et cetera, for the relief that your client is seeking.
Your Honor, I don't think it changes anything. The statute requires that a timely answer be filed, and there's no filed answer on record until April 12th. His attempts to file it on his own, as Your Honor pointed out, it's like you're representing yourself, you're tasked with doing things properly, and the answer wasn't filed timely. So he's in default and has not been opened as a matter of right. And we would request that the answer just be either stricken or not counted, and that a default be entered in favor of Wellstar on both against both Metro Hematology and Dr. Collins.
Okay. Thank you, Mr. Fenimore. So as I said at the beginning of the hearing, there's really no discussion that Metro Hematology is in default, Dr. Collins. Metro Hematology has never filed an answer, and your efforts to file anything on behalf, whether timely or otherwise, on behalf of Metro Hematology are simply not legally valid, because Metro Hematology is a professional corporation and Georgia law is very clear that it has to be represented by an attorney. The separate issue for me is whether or not the efforts to file by Dr. Collins on March the 28th, which would have been timely, then April the 12th, which was untimely, but with no payment of costs, is sufficient to avoid the effect of the default. And unfortunately, I think that Georgia law does not support the position that you're taking, Dr. Collins. The OCGA 91155 is very clear that the party becomes in default if they don't file an answer within 15 days within 15 days of having not answered on the 30th day. And when you file a late answer, you're required to pay costs. Now, that is where we are at this point. And so, as I said, the motion that you filed to set aside a default judgment I'm interpreting it as a motion to open default because there is no default judgment. And in order for the court to open default, I would have to find that an answer had been filed within 15 days or within 45 days, let's just call it, of service, which it was, but also that costs had been paid and they were not. And so for that reason, I am going to find Dr. Collins that you are in default and that the default has not been opened. And so what I'm going to do is enter a default judgment as to Metro Hematology and also Dr. Collins as to you. And then I'll probably get that on file later today or tomorrow, and then the parties may take whatever action they wish to take regarding my decision. I'm very sorry for the difficulties that you're dealing with, Dr. Collins. But this is the court's limited by what the law says, and that's what I have to do based on what the law says.
Judge, can I
Yes,
make
sir.
one more comment?
Yes, sir.
I don't know if you consider this as a passionate plea or a background. What's going on here is that has devastated healthcare in downtown Atlanta. They're devastated. They have closed free clinics. They have 2 hospitals. They closed. 30% of the patients were indigent and uninsured. The ones that did have insurance had Medicaid, which is uninsured. They no longer have anywhere to go. I've had patients' deaths in the emergency room waiting to be seen, waiting literally in terrible pain and dying in the emergency room waiting room before they can be seen.
Dr. Collins, forgive me for interrupting you, but let me say this to you, sir. Number one, I have read the pleadings that you have filed that outline these issues. Number two, I live in Atlanta, right? I too have seen, maybe not upfront and as closely as you have seen it, but I have seen the effects of the closure, the sudden and unexpected closure of Wellstar Atlanta Medical Center. And I've seen what the city has tried to do to address those issues, whether they've been successful or not. Those are all I'm sorry that you are having to deal with those things, sir, and it's unfortunate. But as I said, you are not doing yourself any favors to try and proceed, because those are the types of things that you could address if you had filed a timely answer. We could maybe have those conversations. Although admittedly, this is a contract action, so we wouldn't be getting too far afield of those issues. But I cannot consider those issues because the time for you to raise those issues has legally passed. And so all I can counsel you is that you are not doing yourself any favors by not having an attorney, even if it is financially burdensome to you. And what the court is going to do is enter the default judgments that were requested by Wellstar Atlanta Medical Center. As to both the defendant, Metro Hematology, and as to you, Dr. Collins. And then, as I said, y'all may take whatever action you wish to take in response to that order. Okay, Dr. Collins, do you understand, sir?
I understand.
Okay. Mr. Fenimore, anything else I need to address, sir? You're muted, Mr. Fenimore.
I'm sorry, Your Honor, I mute when it's not my turn to speak.
I understand.
I presented a proposed order to Mr.
I have it, and one of the reasons I was a little more well-versed in the facts than I might normally be on a default is because I was in the process of drafting it in the way that I would find it acceptable for me to enter, outlining those relevant facts and the statutory citations. And so I do have your proposed order. I'm editing it, and I expect that we'll have it on file later today.
Okay, thank you, Your Honor. And I also have a separate writ of possession that I believe I've also submitted.
Yes,
I believe
sir.
Your Honor does those separately, so I submitted each separately.
Yes, I've been told that I need to do the writ of possession separately for that reason, because the sheriff sometimes struggles with them in terms of enforcement and them getting filed appropriately.
It makes sense. I can do it that way too.
Yep, I will get them on file, and then y'all can take whatever steps you would like to. So this matter is concluded. Dr. Collins, good luck to you, sir. Mr. Fenimore, you both may be excused. And then for those of you who are up next, it's going to be the Niskey Lake Falls versus Flavius Harris. But it is 9:24. If you'll give me about 3 minutes to take a quick break and get a little bit more coffee, I'll be right back and we'll get started. Thank you. Okay, thank you for that brief pause. I am ready for Mr. Dickens and Mr. Harris. Mr. Harris, are you still with me?
Yes, I'm here.
Okay, excellent. Thank you. So Mr. Dickens, I'm going to have you go through your default presentation, and then I will hear, because we're actually here on a motion for default judgment associated with Mr. I assume assessments and et cetera. I know there was an issue with like a panel truck, something like that, associated with Mr. Harris's property that's governed by the Niskey Lake Falls Homeowners Association. And so what I'm going to do, Mr. Dickens, is just let you go through that, providing me with dates of service and nature of the underlying dispute, the amount at issue. And then I'll call on Mr. Harris and talk with him for a few minutes. Go ahead, Mr.
Sure.
Dickens.
Good morning, Your Honor. This matter has actually been an issue for a while. At issue is not only the non-payment of homeowner assessments, but also a continuing violation of the governing documents, specifically having a commercial panel van parked at the residence over an extended period of time. Now, my client actually first notified the owner by letter that there was a violation of Article 8, Sections 18, 22, and 23 regarding their commercial panel van. The first notification went to them again in 2022. I believe that was April. Just give me a second for that date. At that time, the owner was notified that failure to cure the violation would result in a $100 a day fine. The owner did fail to cure that violation, and 2 subsequent letters were also sent, but there were no response was received. My office got involved June of 2023. And in fact, on June 9th, my office also sent additional correspondence to the defendant, and the defendant failed to cure the violation, failed to pay the unpaid assessments, and did not contact our office. Suit was filed in this case, and actually it was originally filed in magistrate court, but it was later transferred in November of 2023 to Superior Court. And the complaint was also amended. The amended complaint and the notice of the filing of a motion to transfer, as well as the final order to transfer, were all sent by certified mail to the defendant. The defendant was originally served on September 19th, 2023. No answer has been filed either to the original complaint or the amended complaint. Per our check, the defendant is not currently in the military, so there would be no reason to grant this default. We are asking for what is a total of $39,756.92. My office again has was engaged in June of 2023. And although we do offer some things as a package deal, we typically will bill at the attorney rate of $300 an hour. I've been licensed in Georgia since 2016. The amounts that were necessary in order to adjudicate this matter are reasonable and customary in this area. And again, we are asking for that total of $39,756.92.
Okay. Thank you, Mr. Thank you, Mr. Dickens. I appreciate that. Mr. Harris?
Yes, ma'am.
So a couple of things I need to let you know before I hear from you. I don't know if you were on the call when I was talking to Dr. Collins. I'll give you the same guidance. I know it can be expensive to retain an attorney, but you're almost never doing yourself a favor by trying to represent yourself. Number one. Number two, so what typically is, what I need to make sure you understand in this hearing is that the reason we're here today is that potentially you're already in default of not filing an answer. But you are entitled, if you wish, to have a say in and address the court about whether you owe the amount you owe that's being asserted by the homeowners association. And so the reason I tell you that is to sort of help you understand that what I'm focused on right now is not sort of the larger issues that you might say about, you know, your defenses to the case or whatever. It's really more about, is there a dispute about how much you owe? And to hear from you on that issue.
Yes.
Okay, go ahead, sir.
Well, I do know that I do owe my homeowner fees,
Mhm.
but I think the fees for the van is really excessive considering the fact that we lived in this neighborhood since 2013, and we've always had the van in our yard, in our driveway, and really nobody can see the van where it's parked. And those bylaws changed in 2022, saying that we could not have it, and we expressed to them that at the time we have nowhere to park the van, considering the fact that it's been parked there for over 5 years in our residence. Okay, my wife would like to speak as well.
Hello.
Okay, well,
Hello.
hang on just one second. I am going to hear from Ms. Harris because she's a co-tenant, co-owner of the home, also governed by the bylaws. But just so you know, ma'am, unless you're a lawyer, only Mr. Harris is the party. So I'm technically not supposed to hear from somebody on behalf of another person, but in this limited circumstance, I will. Please go ahead, ma'am.
I truly appreciate that. I just wanted to kind of really elaborate a little bit more on what my husband was saying as far as the van is concerned. So just to clarify, the van is indeed my van because I do own a business. It's called the Vino Van. It's a wine tour company, which several of my neighbors, including the president of our HOA, has been on my wine tours multiple times over the years. And so to respond to the portion that he mentioned that we were not in contact with anyone. So the thing about it is, before any of this, before just at the base, at the core, this is a very small subdivision. Everyone in the subdivision knows everyone. So we are all friends. So though we may not communicate, I guess, from a legal standpoint, as in when the letters were sent to the house, there were still emails being sent back and forth between myself and my neighbors who I refer to on a first name basis as they do me. And there were things that we discussed that I didn't see in any of these documents, but that was from a different type of perspective. But saying that to say it's not a panel vehicle, it's a passenger tour van, basically, that I've had there in my driveway when I established in 2017. And which, of course, at one point in time, I was also on the board of the Niskey Lake Homeowners Association. And so it also says there, as far as if it's absolutely necessary in the means of conducting business, then it is. And in my case, it is because my tours run every single day. I've also spoken with Val, well, Mr. Bates, which is the president, but I've also spoken with Val about that. And an alternative that we did come to was that I could purchase a cover for the van, and it could still be parked in my driveway, and it would just be a cover that I'll purchase for it. So that is something that I do plan to do. But after speaking with them, like I said, that is what we came to, even though it's not in these documents. So maybe that's something that I need to, I don't know, get in writing from Val, just to give to his attorney so they would know that. But as far as the HOA dues, yes, we do understand that we are in default for years 2022, 2023, and then of course our current year dues as well. So those we are not denying at all. And they were due to some unfortunate circumstances. In addition to everything I just mentioned, my mother also moved in with us in 2022 completely, and she's disabled. We've been caring for her. It's been a little strapped, to say the least. And then my husband's rental properties, when the pandemic hit, a lot of the tenants could not afford to stay in those homes. So we lost all of our tenants. And then there were some damages that were done to a couple of the homes. And so that is what we've been playing catch up really for the past couple years, really since 2021, we've been playing catch up, which we've also informed Val about that as well, and did agree to try to catch up so we can come current for this year. We do not plan to go past 2024 owing our dues, because prior to 2021, that had not ever been an issue. We've always paid our dues since we've been living here since 2013. So it was not any ill intent. It was not any, it was not purposeful. It was just due to it was definitely all circumstantial, and not something that we are denying and saying that we're not, because we do enjoy living here. We want to continue to live here. So that's just pretty much. Oh, and then too, at the current time, I also spoke with Val, because we have three students that we had two that one went to college last year, and then two sons that went to college this year. So that is another financial obligation that we are having. With
Well,
those
I can sympathize with that one. I have one in college and two headed there, so I definitely
so you're
understand
just right. You're coming up but that's just where we are financially. But we were my husband and I were discussing our finances, and if they would accept an offer that we have, then we would like to present that offer to get a bulk of this money paid down in reference to the HOA fees, not necessarily in reference to the fees for my van, because it's not like this crazy looking panel van that is stated in this in the documents here.
Okay, thank you for that additional context, ma'am. So I have a couple of questions, and actually my question is for Mr. Dickens. So Mr. and Ms. Harris, just so you understand, as you might have heard me say to Dr. Collins a few minutes ago, unfortunately, a lot of what you have said are the types of things that would be relevant to a defense of the underlying action. And procedurally, if you're in default, then I wouldn't be in a position to consider those things. But Mr. Dickens, one question I do have is that my review of the docket indicates that Misty Lake, so can you tell me why an amended petition was filed? My records indicate document number 8. It looks like it was filed right around the same time as the case was transferred from magistrate court to this court.
Yes, initially this was filed as a complaint for past due assessments, so just the money judgment. However, given the fact that there were multiple notices that there were clear violations of the governing documents for the association, the complaint was amended to also include those violations and the request for an injunction. At that point, not only because of the subject matter, but because of the amounts exceeding the $15,000 jurisdiction in magistrate court, we filed the amended complaint and then a request to transfer this to Superior Court.
Okay. Thank you, Mr. Dickens. The reason I asked you that question is that it has recently been brought to my attention that something that I think I was aware of, but hadn't been reminded of until recently, is that an amended complaint by operation of Georgia law stands denied and does not require an answer. And by extension, there is some case law that says that you can't move for a default on an amended complaint. And so the reason I asked, and I want to fully apologize to both the parties for confusing you, because it was my office that issued an order to the plaintiffs to file a motion for default judgment. Which is why we're here now. But as I said, I will find the case law for you so that it will be in the order. But because under Georgia law, an amended pleading and a supplemental pleading under 911-15 does not require an answer, it stands denied. The case law says you can't move for, you can't get a default judgment on an amended complaint. And so what that means is that the motion for a default judgment would necessarily need to be denied. And then we would need to move forward to schedule this matter and actually try and, I don't know, hearing from the Harrises, perhaps work it out, but put it on some sort of expedited plan to get it to a final pretrial conference and then a trial under the circumstances. Mr. Dickens, I apologize for ordering you to file a motion that I'm now telling you is not something that I can grant. That's entirely the fault of the court. And so I do apologize for the trouble and expense that your client went to. Mr. and Mrs. Harris, just to make sure you understand what's happening here. Normally, you are required to answer a complaint and admit or deny what's alleged in the complaint, and you failed to do that. And so what this hearing was expected to be was a hearing finding you in default and then just discussing the amount of money that you might owe. But as you've heard me point out to Mr. Dickens, because Niskey Lake Falls Homeowners Association filed an amended complaint, Georgia law says that you have officially, by operation of law, denied everything that was alleged in the complaint. And so now that means we need to have a trial and to do the procedural things that would get us to that point. So what will happen is we will issue a scheduling order that will advise the parties of the amount of time. It will be very abbreviated, Mr. Dickens. But actually, I say we'll issue a scheduling order. It will be a 3 to 4 month time window for discovery, unless the parties tell me that they want something different. And then you will be notified when the matter would be on the trial calendar. Now, given what I've heard from the Harrises and from Mr. Dickens, it sounds like perhaps there's some resolution to be had here, maybe a payment plan for the outstanding fees, and then working out some issue with the panel van. I don't know, not my decision, can't control any of that. But this would be the time for y'all to try and work that out prior to the dates that would be scheduled for a pretrial conference and then a trial, assuming there's not any discovery issues that the court needs to deal with. Mr. Dickens, anything else that you would like to share with the court other than being frustrated with the court? Again, I really do apologize, sir.
At this point, other than to ask Mr. Harris to reach out to my office, although I can understand some of what was testified as to today, those were out of court discussions that we were not privy to. And frankly, we just asked that he contact us. Your Honor, I won't ask for a formal mediation at this time, but if I do feel it's necessary, I would like to know if you would entertain a motion to mediate the underlying case itself. And that's, again, if we cannot reach some kind of a resolution.
Absolutely. And I would encourage you to, the Fulton ADR office here in the courthouse is much more, it can be very more affordable than some mediators. And of course, obviously, as this case was originally filed in magistrate, had it continued in magistrate, Mr. Dickens, y'all would have shown up for your hearing date and probably mediated right then and there. And so I would very much encourage you to do that, and happy to enter an order requiring the parties to go to mediation if that's something that y'all want to do, and encourage you to reach out to the Fulton ADR office because it can, like I said, be more affordable for the parties to do that. Anything else that I need to address for the plaintiff, Mr. Dickens?
Nothing further, Your Honor.
Okay. Anything else, Mr. and Mrs. Harris, from your perspective?
No, ma'am.
No, ma'am.
Okay. Two things I'll ask you, Mr. and Mrs. Harris. Number one, did you receive notice of today's hearing either by mail or by email?
By mail.
Yesterday.
Okay.
Well, 2 days.
2 days ago.
Okay. If you would do me a favor and make sure that we have an email address for you, we'll continue to mail things to you. But if we need to send out notices, it's much more efficient if we can send them to you by email.
Yeah.
Mr. Freehoff is my staff attorney. If you see his name there on your screen, his email address is mitchell.freehoff@fultoncountyga.gov. If you want to email him your email address, that's number one. And number two, if you'll please make sure and reach out to Mr. Dickens as he requested, and see if there are some discussions that can be had regarding resolution of the case short of proceeding to trial.
Okay.
And one more time, I'm sorry, what was the,
Yes,
it was
ma'am.
Mitchell dot,
He's put it on the screen now for you. So you should be able to see it at the bottom of that box there.
it went away.
Oh, it's mitchell.freehoff@fultoncountyga.gov.
If he speaks again, okay, there it is.
Okay, I'll talk for a few
Got it.
seconds so you can see it. Sorry.
Oh, okay.
So I'll just keep talking until you have it.
Got it. Thank you so much.
All right, thank you.
Thank you. Have a good day.
Thanks, y'all too.
Okay. And last but not least is the interpleader matter. Miss Jew, if you could do me a favor and sort of walk me through the general, like the genesis of the interpleader funds, and then the parties identified by your client as potential stakeholders. And then I'll call on the various parties to sort of outline for me. I assume your position, Ms. Jew, is simply that we've paid the money in. Can we please be dismissed or discharged, I guess is the right word, from further involvement in the lawsuit now that you've paid the funds in. But if you could address those issues for me, Ms. Chu, that would be very helpful.
Oh, yes, Your Honor. So we first filed this interpleader action because of the excess funds from the foreclosure sale of the property at 8828 Lake Crest Way. It was previously owned by Rosalind Robinson, and we identified her 4 heirs, and we recognize there's probate file for her, but since the letters of administration is conditional, and there are 2 more lien holders that may have interest attached to the property. That's why we decided to file an interpleader action. And up for now, all the named heirs has been filed, and they have filed an answer as well. Fidelity and the HOA, the Valley Lakes Community Association have been served and also filed an answer. All the unknown heirs has been served, and the publication affidavit has been filed on April the 16th. And we have a pending motion to deposit the fund. We haven't sent the fund yet. We're waiting for Your Honor to rule on it. And we also presented a motion to dismiss and affidavit for attorney's fees and cost. And we're just trying to decide, trying to ask the court to please dismiss us from this case and award us attorney's fees and costs so that we don't include any more legal fees.
Understood. And just so you understand, Ms. Jew, the only reason that I've not yet granted the motion is because in interpleaders, I found it very efficient to try and get everybody at the same place. And sometimes we can end up with one order that addresses everything. Sometimes we can't when there are disputes that need to be revisited by perhaps some of the parties, the stakeholders to the interpled funds. Then I will, let the interpleader out, assuming that it's all been properly done, which it appears it has. But that's the only reason I haven't let you out, is to see where we are now, and then I will decide procedurally what to do regarding that motion to deposit funds and then be released from the interpleader. Okay, so let me start by hearing from Mr. Kyler. Did I understand that you are the attorney that represents the Ruffin family members that might be beneficiaries of the estate, et cetera?
Yes, Your Honor, you did get that correct.
Okay, and am I also correct that, so there is Fidelity National and then Community Association of Valley Lakes? Can you tell me, Mr. Kyler, what are the Ruffin family members, your client's position relative to the entitlement of Community and Fidelity and the priority of those claims if you don't dispute that they're entitled to assert them?
Yes, Your Honor. With regards to Valley Lakes, the homeowners association funds, there's no dispute as to them having first priority lien, and we do not dispute Valley Lakes asserting their first priority lien with regards to their funds. The only contention that the heirs have is with regards to the Fidelity National Insurance claim, and we would like to just put forth some information as to why we are, disputing that validity of that lien in amount.
Okay, hang on one second, Mr. Kyler, before you get there. I'm gonna ask Mr. Stewart, you represent Fidelity, is that right?
Yes, Your Honor.
Okay, what is the amount of the claimed entitlement that Fidelity is asserting?
Well, the lien is over, it's over 100 grand at this point. But I believe that the lien wouldn't attach to all the proceeds regardless. It sounds like there's an estate that should have been carved up, and at best it would attach really to a portion that would go to one heir, as best I can tell.
Okay, well, I'm gonna hear from Mr. Kyler regarding that issue. I just was trying to get a lay of the land. Mr.
Right.
Sauls, I'm only not calling on you because it sounds like nobody's disputing your entitlement. But can you tell me, Mr. Sauls, the amount of the lien or entitlement that Community Valley Lakes is claiming?
Yes, Your Honor. Valley Lakes we filed a verified answer on verified claim on their behalf. At the time it was filed, the amount was $2,097.71. Since then, there's been some additional attorney's time, just researching the priority issue and everything. At this point now, we are at $2,579.43. You're looking at basically a $480.74 difference there. My billing rate for this matter is $250 an hour. Lisa First, who's the other attorney on it, her billing rate is $275 an hour. So we're talking less than 2 hours worth of time there, Your Honor. We would assert that given the issues involved, that was reasonable and necessary and consistent with the fees that are charged for similar work in this area, and would request the court award Valley Lakes $2,578.43.
I apologize. Did you say 2578.43?
Correct, Your Honor.
Okay, thank you. I had written it down wrong. Okay. And okay, so then now that takes me back. Mr. Kyler, can you please, I'm going to call on Mr. Kyler to sort of walk me through your client's challenge to the entitlement for fidelity. And then Mr. Stewart, I'm going to come back to you and let you talk through that with me a little bit more detail. Okay.
Okay.
Thank you. Mr. Kyler?
Yes, Your Honor. So the underlying issue arises from a complaint. It's a 2-count complaint. The first count being a breach of contract, and then the second count is a personal guarantee. So Mr. Stewart is correct with regards to the fidelity claim being attached only to Angela Ruffin. The other 3 heirs have nothing to do with this matter. The judgment on that case was entered March 6, 2012, and the writ of FIFE was recorded March the 23rd, 2012. This was in regards to a title insurance issue with regards to the breach of claim situation. And I reached out to Mr. Stewart back in January to verify the lien. I submitted to him the Social Security number of Miss Angela Ruffin, also her driver's license, to verify that this lien is actually valid with regards to her. And we've come to the position that this is not the same Angela Ruffin that I represent. Ms. Ruffin has never lived in the state of Georgia. Her only connection to the state of Georgia is her mother. And Mr. Stewart presented the complaint along with the personal guarantee that the underlying issue surrounds. And in the personal guarantee, it has an address for the Angela Ruffin that is at issue here. And that address has never been associated with my client. And I presented that information to him in hopes of trying to get this resolved ahead of today's hearing. We haven't been able to come to a conclusion about that matter, but I just wanted to state to the court that we've submitted Ms. Angela Ruffin's, like I said, socials and also her driver's license to try to get this matter verified, and haven't been able to do so. And it's our position that the lien in the judgment isn't against the same Angela Ruffin that we represent. In the alternative, we also just want to bring it to the court's attention that the writ of FIFE was recorded, like I said, back in March 2012. I searched the clerk's site and did not see a nola bona, which would extend the validity of the judgment lien. But that was back in January. I don't know if one has been filed since then. So we would also contest the validity of the judgment as it has been expired under Georgia statute law.
Okay, Mr. Kyler, before I hear from Mr. Stewart, let me back up and ask a much simpler question. First, I appreciate you outlining that for me and identifying that I think I understand that the nature of Fidelity's claim is as to any entitlement Ms. Ruffin individually might have. But you represent other claimants that would potentially be entitled. So my understanding is that the amount that was that sought to be interpled is $78,534. There would be some attorney's fees. I don't know the number off the top of my head. And then nobody's disputing the community lien because it would, of course, attach to the property that's at issue. And so my guess is there's about 70 grand-ish that's at issue here. Relative to the other claimants, setting aside, are these all equal claimants in terms of dividing the proceeds equally among how many people?
4.
4 people. So, okay. And so Mr. I'm going to call on Mr. Stewart now. Mr. Stewart, am I correct in understanding that your position, I think as what you said before, and then also as outlined by Mr. Kyler, is that if there's 70 grand left, that
Right.
you would be seeking to recover 1/4 of it if in fact you're attached to Angela Ruffin. Is that right?
Yeah, it would only be to Angela. So, I mean, it sounds like there's multiple heirs that just, for whatever reason, didn't go through probate correctly to get this titled out right. And so if they had, she would have had, sounds like a 25% share of whatever was there. So I think that's probably the most we would equitably have an entitlement to. I mean, this is kind of a equitable type of matter at this point, and the court has to take some discretion from an equitable standpoint, I believe. So I would agree that I believe 25% of whatever's left sounds like the most we would have a claim on.
Okay. So here's what I think I might do. It sounds like you, Mr. Stewart, you and Mr. Kyler are in the process of sort of getting to the bottom of this issue associated with.
And there was a renewal on the 5A, Judge. I just pulled it up while he was speaking. I got a nulla bona and a lien and page on that, but.
Okay, can you, I don't have any reason to question if you tell me there was a renewal, but do you have a page number for me?
Lien book 4255, page 695.
Thank you. And when was that?
2018.
Okay.
September 11th, 2018.
Okay, thank you, sir.
Which would have had another 7 years.
Okay. So assuming that addresses the second issue that Mr. Kyler raised, then really the main issue is for y'all to get to the bottom of whether there's going to continue to be a dispute as to Angela Ruffin and whether Angela Ruffin is the person against whom this judgment would attach. And so one option that I have is to grant Ms. Zhu and Mr. Saul's clients the relief that they seek, and even also to grant the 3 remaining claimants the relief that they seek. And then to hold the remaining disputed amount as to Ms. Ruffin temporarily while the parties figure out if there's going to be agreement or if we need to have an evidentiary hearing regarding the issue of whether or not Angela Ruffin is this Angela Ruffin, therefore entitling Fidelity to attempt to recover those funds. What do you think about that approach, Mr. Kyler?
I have one issue with that. That is a great resolution, but the information that we would put forth in the evidentiary hearing have already been provided with regards to Miss Angela Ruffin's social, also her driver's license, and the fact that she has never been a resident of the state of Georgia. So that information has already been presented to Mr. Stewart, and I don't know what his review of the information is, but I think it would kind of be for lack of a better words, redundant because we've already done what we would do in an evidentiary setting.
Well, here's what the reason I'm suggesting it is I think I'm understanding Mr. Stewart, giving him the benefit of the doubt here, that he either does not find that information to be credible or has not had an opportunity to fully review it and decide if he finds that information to be credible. Either way, one of two things will happen. Either Mr. Stewart and his client will review the information, determine that it is credible, that this is likely not the same Angela Ruffin, and then y'all can negotiate the resolution of that claim and submit to me a consent order. Or if Mr. Stewart and his client determine that they don't find that information credible, then we would have an evidentiary hearing and y'all would present that information to me and I would determine if I found it credible. And if I did, I would say that, you know, this doesn't attach to Ms. Ruffin because it's not the same as Ruffin, and give her those funds. And keep in mind, I'm talking about doing this in the next week to 2 weeks. So I don't want to unnecessarily delay the resolution of this matter. But I just wanted to give a little bit more time for Mr. Stewart's client to assess the information you've provided and then figure out what they're going to do with it. And then very quickly behind that, have a hearing regarding who is Angela Ruffin that is claiming these funds versus who is Angela Ruffin that against whom a judgment was entered on a personal guarantee back in 2012. Mr. Stewart, what are your thoughts, sir?
That sounds fine, Judge. I mean, obviously this was a title claim, so it wasn't like a contract claim where we've got a application with social security numbers and photocopies of licenses and that kind of thing.
Right.
So that does make it a little harder. I mean, if we had some sort of affidavit with some more history from her or something else, that might help. But like I say, it's not like something where it was more tort based the way it came across from my client. So we're not with the background information we would have like a breach of contract case or something else where we could really easily positively identify one or the other.
Right. Well, I mean,
Yeah.
it is that is oftentimes one of the difficulties of trying to enforce a lien that has this much age on it. But, you know, at the end of the day, all y'all can do is try to gather as much information as you can to either convince you or if you believe it needs to be, you know, for me to determine. And so I guess my question is, looking at my calendar, if I were to put this on for sometime in late May, like, as I said, in about 2 weeks, like May 30th, May 31st, somewhere in there, would that be enough time for the parties to gather the information, either to assess it on your behalf, Mr. Stewart, for your client, or to gather information to be prepared to present it to me?
Yes, the 30th, that should be enough time. The 30th, I'm pretty booked up. The 31st, I could do later after lunch, afternoon time.
Okay. Mr. Kyler?
The 31st is fine for me.
Okay. Okay, so here's what, so then thank you both very much. I will send a notice to Mr. Stewart and Mr. Kyler regarding the setting of an evidentiary hearing at 1 p.m. or after, sometime in the afternoon on May the 31st.
Okay.
In the interim, Mr. Sauls and Ms. Jew, what I can do is I can go ahead and enter a consent order if someone wants to prepare one for me that authorizes the payment into the registry of the court, that authorizes the dismissal or discharge of the interpleading party, the satisfaction of their attorney's fees, and the payment to Mr. Saul's client of the $2,578.43, and the remaining payments to the 3 Ruffin claimants that would be entitled. If somebody wants to send that to me, I do have a format that I prefer, which is literally just what I've outlined. Give me, what I like is one order that outlines everything about the case so that 5 years from now or 8 years from now or whatever, if we need to go back and look, we know what's happened in the case in one document. So a brief history of how the interplead funds came to exist, how you, just like you outlined for me today, how you identified the claimants, that the claimants were served, which claimants answered, and then the agreement that everyone has to make payments out, and then I will do, therefore, based on all this, the court orders, the money can be interpled. The interpleading party is entitled to discharge and their payment of attorney's fees. And then the following payments shall be made by check to these addresses. I'll do all that as soon as someone wants to get me an order to that effect, a consent order to that effect. And then I will retain that last dollar amount for that hearing on May 31st, and we'll issue an order depending on the outcome of that, either a consent order coming from the parties if there's agreement, or as a result of the hearing on May the 31st. Does that work for everybody? Ms. Zhu?
Yes, Your Honor. I believe we have prepared a proposed final order. I
Okay.
can revise that accordingly to what how the outcome is today, and leave the last part to Miss Angela Ruffin and to Fidelity, and that part to be filled in after the hearing.
Okay, thank you. If you can do that and send that over to us in Word format, Mr. Sauls, will that work for your client, sir?
Yes, Your Honor, I'll be around all day today, so if she wants to shoot it over to me, I can take a look and
Right.
send.
And just make sure I have the right address. If those funds if the clerk needs to issue a check and it's going to go to you, or it's going to go to some corporate office, just make sure, because the way it typically reads is, the clerk shall pay X dollars to Community Association of Valley Lakes, Inc. by check payable to and mailed to whomever.
Okay,
So if y'all can make sure we have that information, we'll get it on file for you.
all right. We will
Yes,
do
Your
that.
Honor.
Thank you all very much. Mr. Kyler, Mr. Stewart, y'all will also need to, Mr. Kyler, you'll need to sign off on the consent order relative to your other clients. And then Mr. Stewart and Mr. Kyler, I'll either look for another order from you guys if y'all resolve it, or I will see you on May 31st.